Hi, my name is Bob Menges. In this fourth and final video form for Liberty University's American Revolution course, I'm going to be discussing what is referred to as the Confrontation Clause of the Sixth Amendment found in the United States Constitution's Bill of Rights. It is imperative in any analysis of history to recognize that God has established order, intelligence, and truth in the universe and history. Acts 17, 25, and 28. Jeffrey Fisher, in his article, Originalism as an Anchor for the Sixth Amendment, explains that the clause provides that a criminal defendant has the right to be confronted with the witnesses against him or her. On the surface, this sounds pretty straightforward, but modern technology has added a wrinkle that has caused controversy in recent years. With that in mind, it's helpful to first explain the origins of the clause. In his article, The Origins of the Confrontation Clause, An Alternative History, Randolph Jonicate states that the framers remembered the harms and injuries suffered by the colonists in this area, which compelled them to add a right to prevent abuse common in 16th and 17th century England, where defendants were prosecuted without witnesses and by hearsay. Richard Friedman, in his article, The Confrontation Clause Rerooted and Transformed, offers the notorious case of Sir Walter Raleigh, in which Crown prosecutors used confessions made by alleged accomplices of the accused, even though the confessions were not made under oath or before the accused. The self-accusing nature of such statements was said to be an adequate substitute for the usual requirements of testimony. Friedman goes on to say that the right became a particular focus of American concerns in the 1760s when the Stamp Acts and other parliamentary regulations permitted prosecutions based on the examination of witness statements. Not surprisingly, the early state constitutions guaranteed this right. Kristen Slider, in her 2005 University of Arkansas at Little Rock Law Review article, says that the clause is composed of just 18 words, yet this small phrase has become an enigma for the United States Supreme Court in the past half-century. She argues the court has merged an absolute constitutional right with the rule against hearsay, and in doing so has subjected the categorical right of confrontation to a malleable standard of evidence law that often fails to protect against confrontation violations. The landmark Supreme Court case on this subject came in 1990 in Maryland v. Craig, a case that Jeremy Blumenthal says set the constitutional standard for such rulings. The case dealt specifically with the Confrontation Clause and modern technology. A young girl who had been abused by a child molester gave evidence through closed-circuit television, and the accused woman argued that not being able to have a face-to-face courtroom encounter with her accuser was unconstitutional under the Sixth Amendment's Confrontation Clause. The court, in a 5-4 opinion, ruled that the closed-circuit testimony was constitutional and that the right to face-to-face meetings with witnesses at trial was not absolute. In his dissenting opinion, the late Justice Antonin Scalia argued that permitting a child witness to testify via closed-circuit television in order to avoid the trauma of being in the immediate presence of the defendant violated what he saw as the defendant's absolute right to the face-to-face confrontation guaranteed by the Sixth Amendment. He stated, "The purpose of enshrining this protection in the Constitution was to assure that none of the many policy interests from time to time pursued by statutory law could overcome a defendant's right to face his or her accusers in court." In a captivating interview with Justice Scalia on CNN, Piers Morgan asked Scalia, "What part of human decency or common sense says that she should have the right to be face-to-face with her young girl victim?" Scalia responded, "All legal rules do not come out with a perfect, sensible answer in every case." He said the Confrontation Clause in some situations does seem to be unnecessary, but there it is, and its meaning could not be clearer. You are entitled to be confronted with the witnesses against you. Morgan responded, "Even when the witness is a young girl who has already been abused and traumatized?" To which Scalia responded, "What it says is what it says. I'm doing what I'm supposed to be doing, applying the Constitution. I do not always like the result. Very often I think the result is terrible. But that's not my job. I'm not king, and I have not been charged with making the Constitution come out right all the time." The Confrontation Clause is a great example of how constitutional rights sometimes create tension in modern times. Scalia's position may sound harsh, but he was attempting to be faithful to the original text of the Constitution. Remember, the framers gave us an orderly process for amending the Constitution in Article 5, rather than having unelected judges changing the meaning by judicial fiat. I encourage you to watch the 2-minute clip from the interview. Thank you very much.